This podcast is brought to you by the IIEA, sharing ideas, shaping policy.
Good afternoon. My name is Alex White. I'm Director General of the Institute of International and European Affairs, and I'm pleased to welcome you to this IIEA webinar addressing certain important legal aspects of the ongoing conflict in the Middle East. In July of this year, as I'm sure you're aware, the International Court of Justice issued an advisory opinion when the occupation by Israel of Palestinian territories post-1967 was declared to be illegal. And that request for an opinion from the court was made by the General Assembly of the United Nations. It has to be distinguished from a separate ICJ case, an application brought by South Africa under the Genocide Convention. And in that case, the court issued so-called provisional measures back in January of this year, requiring the state of Israel, quote, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to Palestinians in Gaza, to take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, unquote. Entirely separately, again, there is the application by the Chief Prosecutor of the International Criminal Court for arrest warrants in respect of the Israeli Prime Minister and the Minister for Defense, as well as of 3 senior Hamas figures. So, and there are other cases ongoing internationally which touch on important questions of international law, which we are going to explore in this seminar here at the IIEA this afternoon. Thank you, as I say, for joining us. Our panel, I'll introduce them in a moment. We have 3 experts joining us, and they'll set out their views on these legal developments. And we're, of course, confining as best we can the discussion to these legal issues, but of course, we may range beyond the strictly legal questions, but that's the basis for our conversation this afternoon. And we'll have an opportunity in that context also to reflect on Ireland's position on these questions of international law as have arisen in the course of the cases I mentioned, noting that the Attorney General, Rossa Fanning, appeared personally at the hearing in The Hague last February in relation to the General Assembly request for an opinion, and made, I think it would be generally agreed to be, some very trenchant submissions on that occasion on behalf of Ireland. We're also aware that the government in recent days has said that it is again considering how to proceed with the Occupied Territories Bill, which would restrict trade with Israeli settlements in the West Bank. And the Taoiseach stated in recent days that the Attorney General has advised that, and I quote, the context of how we might move forward on this issue has now changed because of the International Court of Justice's advisory opinion in July. So there's a lot that we could talk about. And as I mentioned, we're pleased to be joined today by 3 legal experts. Giulia Pinzauti is Assistant Professor of Public International Law at Leiden University. Dr. John Reynolds is Associate Professor of International Law at Maynooth University, and Professor Hélène Giulia is Professor of Public International Law at Aix-Marseille University. And she is delayed just by a few minutes, I'm advised, but we're hopeful that Hélène will be in a position to join us shortly. But we can go, first of all, to our first of our 3 speakers. Giulia Pinzauti is Assistant Professor of Public International Law at the Grotius Centre for International Legal Studies of Leiden Law School. She previously served as an Associate Legal Officer at the International Court of Justice from 2015 to 2016, in the office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia from 2012 to 2014, and also at the Special Tribunal for Lebanon back in 2011-2012. So qualified, certainly, without doubt, and I'm sure with many insights. We would ask you, Giulia, maybe just as our first speaker, to just give us the general context for these cases that have arisen internationally, where we are in relation to them, and just a broad opening for us for our conversation. Over to you.
Thanks very much for the introduction, for having me today. In the time that I have, I'd like to give you a brief overview of the ICJ's engagement with the situation in Palestine and to explain the court's key findings in the cases so far. So first of all, I think it's important to mention that for about 56 years since the beginning of Israel's occupation, it wasn't possible to begin a contentious case against Israel in relation to the occupation itself, because the court's contentious jurisdiction, that is, its work on the settlement of international disputes, has certain limits. Most notably, it's based on consent of the state parties to a particular dispute. Now, consent to the jurisdiction of the ICJ can be expressed in two main ways, through treaties or through the so-called optional clause declarations. But Israel typically doesn't consent to ICJ jurisdiction, with the exception of the Genocide Convention, and that's why the convention is so important. I'll come back to that. So the court's only engagement with the situation in Palestine for a long time was through advisory opinions. These opinions can be requested by the General Assembly or the Security Council on any legal questions. So in 2003, the General Assembly requested the court to deliver an advisory opinion on the legality of the construction of the wall in the occupied Palestinian territory by Israel. Because this is an opinion, it's not binding, consent is not required in this case, but in practice, it is a way to bring contentious matters before the court through the back door, so to say. So in 2004, the court ruled that the wall and the legal regime associated with it are contrary to international law. The wall is a fact on the ground that may well become permanent, the court said, and in that case, it would amount to de facto annexation of parts of Palestine's territory by Israel. The court also spelled out the consequences of the illegality, that Israel must dismantle the wall and provide compensation for the harm caused, which of course didn't happen, as we know. Then we fast forward to December 2022, when the General Assembly requested a second advisory opinion from the court that was just mentioned on the legality of Israel's occupation. But while these advisory proceedings were ongoing, the 7th of October attacks happened, and Israel's massive military response on and against the Gaza Strip. So this is what triggered the initiation of two contentious cases against Israel and one of its closest ally, Germany, for their role in the conflict. The first case was brought by South Africa against Israel on the basis of Article 9 of the Genocide Convention. This article provides that any disputes related to the interpretation or application of the convention can be brought before the International Court of Justice. And you may wonder, why South Africa, that is not directly injured by the alleged commission of genocide in the Gaza Strip? It's possible for South Africa to bring this case because the obligations enshrined in the Genocide Convention are not simply bilateral obligations that are owed to one state to another state, but they're owed by each state party to all of the other state parties. And this gives every state party the standing to bring a case against any other state party concerning alleged violations of the convention, even if it's not directly injured by the violation. South Africa's case at its core is that Israel has violated the Genocide Convention by committing genocide against Palestinians in Gaza and by failing to prevent it. Genocide is a very serious crime whose essence is, in brief, the destruction of a protected national, ethnic, racial, or religious group in whole or in part. And in its application, South Africa argues that Israel is killing Palestinians in large numbers through its relentless pounding of the Gaza Strip. It's causing them serious bodily and mental harm, imposing measures that are intended to prevent Palestinian births within the group, and inflicting conditions of life that are calculated to bring about the destruction of the group in the long run through the deprivation of food, water, fuel, medical supplies. So while this case might take several years to reach a ruling on the merits, South Africa has asked the court to issue provisional measures. These are urgent measures that are needed to protect the Palestinian people from further harm and safeguard South Africa's ability to have the case fairly adjudicated in the merits pending resolution of the case. The court has already indicated provisional measures 3 times. 3 times it has warned Israel, its allies, and the whole international community that Palestinians in Gaza are at risk of genocide. The measures that the court indicated in its decisions have become, I would say, increasingly more specific, more detailed. If we look at the latest decision from May 2024, the court reaffirmed the measures that it indicated previously in January and in March, including the cessation of any genocidal acts, the delivery of humanitarian assistance to Gaza's population, but it also ordered Israel to suspend its military operations in Rafah governorate, something that had been debated a lot amongst legal scholars, probably was already implicit in previous decisions, but in May, the court said it very loud and clear. It ordered Israel to maintain the Rafah crossing open for the delivery of humanitarian aid and ordered Israel to grant unimpeded access to the Strip by UN investigative bodies. So the court really sent a strong message to Israel and to the entire world. It's also undeniable and regrettable that Israel didn't comply with the court's orders. This is in itself a violation of international law because provisional measures orders are binding. So when the court will issue a decision on the merits, it will ascertain that Israel breached the provisional measures orders. But we cannot wait until then. This might take a few years from now. We need to act right now. And whether the court's rulings that are so important will be able to protect Palestinians in Gaza or not actually depends on the actions of third states, including Ireland, and international organizations, because they are the actors that have the capacity to influence Israel's actions. Not just that, they're legally obliged to do so because of their own obligations to prevent genocide as states parties to the convention and not to be complicit in Israel's violations of the convention. And I believe that Dr. Reynolds will further elaborate on this point. I just want to briefly mention the other contentious case that was brought by Nicaragua versus Germany. It's really against this backdrop of the South Africa case that Nicaragua instituted proceedings against Germany, arguing that through its continued provision of military assistance to Israel, Germany is failing in its own obligation to prevent genocide and to ensure respect for the Geneva Conventions. Nicaragua also requested the indication of provisional measures to ensure that the weapons already delivered by Germany to Israel wouldn't be used to commit or to facilitate the commission of international law violations, and to enjoin Germany to resume its financial support for UNRWA. On the facts presented by Germany and accepted by the court declined to indicate provisional measures this time, but it didn't throw the case out as Germany had requested. It remained seized of the case and took the opportunity to express its deep concerns for the grave humanitarian situation in Gaza and to affirm that state parties to the Genocide Convention, to the Geneva Conventions, have the duty to be proactive in ascertaining and avoiding the risk that when they supply weapons to a party to a conflict, that these weapons might be used to violate the convention. So the implications of this case, I think, are very far-reaching, and certainly more than one might think. If you look back on these cases, the court's findings are based on a very low standard of proof because we're at the provisional measure stage. So the court has only ascertained that genocide is plausible. This is a much lower standard than the fully conclusive proof that is required to make a finding on the merits that genocide was committed. Excuse me. But still, I think that no state should ever get to the point where genocide is even plausible because of the seriousness of the allegations. The allegations of genocide, I think, also have a very particular symbolic force, due, of course, to the Holocaust, in a way that perhaps other international crimes do not. The flip side of that is that in these contentious cases, the court's jurisdiction is limited to ascertaining allegations of genocide, which provides the basis for the court's jurisdiction, and genocide only, so the court cannot consider IHL compliance or other violations of international law. But this is why I think the advisory proceedings on the legality of the occupation are so important, because they have this much broader scope. In July, as was mentioned, the court concluded that the occupation is illegal. So it's Israel's very presence in the occupied Palestinian territory is contrary to international law. This illegality stems from a number of policies and practices, such as the settlements, for example, that constitute unlawful acquisition of territory by force and breach the right of the Palestinian people to self-determination. The court has also characterized Israel discriminatory legislation as apartheid or racial segregation. There's a little bit of ambiguity there, and address the consequences for Israel that must terminate the occupation and provide reparation, and also for third states and the UN. So groundbreaking decisions in many respects, in significance and scope. And I'm gonna leave it at that.
Thank you very much for that. Wonderful just summary of, issues of enormous import and seriousness, and almost you often feel, I'm sure, as an academic, that it can be not assuming this, but it's very difficult to reduce issues of such enormity to 7 minutes or whatever it is that you've done. But thank you for that. And there's much there to discuss. And I think struck by what you said at the outset, that which we're aware of, but it bears repeating, that all state parties have an interest. I mean, in a sense, on the question of standing, every state has standing, and it's quite a profound point to remember in these matters, that sometimes the pushback can be, well, look, where's the interest involved, or where's the involvement, or what? But the point you make is that as a matter of law, international law, all states have standing on these questions, and that's something that's worth bearing in mind. I'm going to go next to John Reynolds, is Associate Professor of International Law at the School of Law and Criminology at Maynooth University. And John's research focuses on questions of international law in relation to colonialism, apartheid, and states of emergency. His book on empire, emergency, and international law was published with Cambridge University Press and won the Kevin Boyle Book Prize for Outstanding Legal Scholarship. John, I'm going to ask you just to pick up perhaps there where Giulia left off, to reflect on some of those cases that she has spoken of, and perhaps also to take a moment to reflect on Ireland's role, Ireland's involvement, particularly on the advisory opinion case, and where what the implications that might be domestically here in terms of how we approach the Occupied Territories Bill. But take it wherever you choose. It's over to you. Thanks for joining us, John.
Sure. Yeah. Thanks very much for the invitation. So I'll try and address primarily, I think, those questions are in relation to Ireland and how this does impact Ireland's role and involvement. That might be, I think, the most interesting to focus on, but still the time is obviously limited, so I'm happy to talk more in the discussion afterwards. I will just start with one, I suppose, element of context, or a caveat, which I'm kind of compelled just to mention, just based on my own research that you mentioned, and the background I'm coming from on this, which is about international law's complicity really historically for a long time in colonial power dynamics and in European imperialism in the world. And, we have a long history of 500 years of international law really being a vehicle for imperialism and injustice in many ways. And it's only really slowly changing since the 1960s, really, since the former colonized nations have become part of the UN, and that we have a more democratic kind of international order, at least on paper since then, that, things have started to change. And so the International Court of Justice is part of that, is not immune from that, and does have its own somewhat patchy history as well on questions of global justice, self-determination. And we can think of, some quite conservative and problematic decisions from the court in the 1960s, for example, kind of more or less in favor of apartheid South Africa at the time, where some of its policies were being challenged by Ethiopia and Liberia. Other situations that have come up since then, famous case in the 1980s, where there was a strong decision against the US over its illegal intervention and use of force in Nicaragua, where the court found it, to have breached international law, reparations being due, but that wasn't enforced, and the US used its veto on the Security Council to block that. And so we have, these kind of difficult dynamics there, and the kind of the engagement by global South states particularly has been affected by that. There was a disillusionment with the court after the failure to enforce the Nicaragua decision, and it's only really in recent years that the global South states particularly have been more actively engaged with the court, and are really the ones that have been taking the lead, on in the international institutions and in international relations generally on Palestine in recent years and recent decades, and obviously particularly in the past year, with South Africa and Nicaragua taking these cases themselves in the International Court of Justice, but also some of the other global South countries imposing trade measures, diplomatic sanctions, and other measures against Israel. So when it comes to Ireland's role, we've obviously had a lot of strong words and some kind of gestures towards symbolic action from Ireland, but very little action really during the past year of Israel's genocide, or really over the past number of decades, where the not just legal but also moral imperatives of taking action against the Israeli occupation, the apartheid regime, have been clear for a long time, going back to the original advisory opinion that Giulia mentioned 20 years ago and before that. And so in terms of the implications of these rulings, let's say, between the advisory opinion and the various provisional measures orders this year for Ireland, I'll try and just emphasize maybe a couple of points for now, and happy to pick it up then in the discussion again afterwards. But one, I suppose, is as you've kind of alluded to on the advisory opinion on the illegal occupation, and what that tells us, or what that means for the Occupied Territories Bill and related trade issues. And so speak a little bit to that. And then the other second point, if I have time, just on the provisional measures orders in the two cases, in particular the South Africa case, and what that means for Ireland's obligations to prevent genocide and not to aid or assist genocide and war crimes, which also comes into play with the Nicaragua decision as well.
John, would you mind if I just interrupt for one brief moment, just to remind everybody who's watching that they can insert a question into the Q&A. I overlooked doing that at the outset, and I wanted to, once it's just occurred to me now, I want to do it as soon as I can. If you're interested and you've got a question, please put it into the Q&A. Tell us who you are if you don't mind. Some people already have done it. Give us your name, certainly, and your designation if you have one, and we'll get to those questions once we've heard from our panelists. And the shorter and the pithier, if that's the word, question you put in, the more likely we are to reach it. Sorry to interrupt you, John. I thought you mightn't mind me just doing that.
Yeah, that's no bother at all. Yeah. So on the advisory opinion, I mean, Giulia's kind of laid it out well there, but we have the duty basically not to recognize, not to aid or assist in any way the illegal occupation, or what the court also talks about as annexation and as a regime of racial segregation and apartheid in the Palestinian territory that Israel has imposed. And so the language, some of the key language from the advisory opinion is around it. Let's say if we take Ireland's obligation in this case, so Ireland's obligation, the obligation of all states to abstain from treaty relations with Israel in all cases in which it purports to act on behalf of the Palestinian territory, to abstain from entering into economic or trade dealings with Israel concerning the occupied territory, which may entrench its unlawful presence in the territory, and also to take steps to prevent trade or investment relations that assist in the maintenance of the illegal situation created by Israel in the Palestinian territory. Right? There's more to it. There's more elements, but there are some of the key points that the court makes. And it really, you know, the upshot is that this really requires all states, including Ireland, to really fully review their diplomatic, political, economic, cultural, military relations with Israel on all fronts. There was then the General Assembly resolution in September that gave effect to the advisory opinion, endorsed it, and also called for the illegal occupation to be ended within a period of 12 months. And Ireland voted in favour of that resolution, but also, I think, significantly co-sponsored it as well. And so the position rhetorically from the government has been clear. And so one question that comes up then is what does that mean in terms of concrete action? The Occupied Territories Bill obviously has been in the discussion, as you mentioned recently. You know, the basic kind of element of banning imports from Israeli settlements is very evidently not just in line with, but required by what the advisory opinion says. That was clear, I think, already from 2004 and the original advisory opinion, which dealt very comprehensively with the illegality of the settlements. And so, in one sense, the best time to pass the Occupied Territories Bill was in 2018 when it had already the parliamentary majority at that point. But as we know, it was blocked by the government at the time. The next best time, I suppose, is now to do so. And I think it's clear that that's in many ways the minimal obligation that the advisory opinion would require. And actually, if we look at the language of it, it's not just about banning relations with the illegal settlements themselves, but it's about abstaining from trade or economic dealings which in any way may entrench the unlawful presence in the Palestinian territory or assist in its continuation. So it's not just about direct trade with the settlements itself. It's about the broader economic and trade dealings with the Israeli state. And I think one thing that is important to emphasize, international law makes a very kind of clear distinction. There is a green line between 1948 and 1967 Palestine, and that's the partition line, and that's how we separate the territory. But in the way that the Israeli state and the Israeli economy operates, that dividing line is not so clear at all, and in many ways it's non-existent. And we see, even the Israeli Prime Minister going to the UN General Assembly and holding up the map of Israel, and there's no partition line there. It's all Israel, and the Palestinian territory is all considered as Israel. And so when one of the figures that's come up in relation to the Occupied Territories Bill is that there's around approximately €1 million worth of imports from Ireland directly from the Israeli settlements annually. So I'm not sure exactly how accurate the source of that figure, but if we take that as as €1 million per year, and we look at the overall imports from Israel into Ireland in 2023, for example, it was close to 4 billion. And so if we put those figures side by side, we think about how the Israeli economy operates, we think about how so much of the trade that is happening is not, there's points in the production line or the value chain that are, is maybe originating from a settlement or from inside the occupied territory, but coming through Israel. And so, the 1 million out of 4 billion is a tiny fraction of a percentage, but the territory of the Palestinian territory as part of Israel's overall jurisdiction is 22% of the territory altogether. The settler population in the West Bank is around up to around 10% of the Israeli population, and so it is a much more significant factor than those figures might make us believe. And clearly, the level of trade, Ireland is now Israel's fourth largest export market. It is a huge level of trade, particularly in the tech and electronic components sector. And so, in many ways, the obligations set out by the advisory opinion require us to go a lot further than just what's labeled and clearly designated as coming directly from from an illegal settlement. And so that does require that much more extensive kind of review, I think, of the interactions we have. And we can think about, questions of that language about assisting in the maintenance of the illegal situation, the role of the role of the big tech companies and their relations with the Israeli security apparatus and military as well, documented Amazon, Google, and so on, but also companies like Motorola and others that are very actively providing surveillance technology to the settlements and the settlement infrastructure and the security kind of arrangements that go around that. And so it penetrates a lot deeper than just particular products that are grown themselves on settlement on lands. And so I think ending trade with the settlements is the first step, but that would only partly meet the duty not to aid or assist the unlawful occupation.
This podcast is brought to you by the IIEA, sharing ideas, shaping policy.